Morning.
Morning.
Good morning, ma'am.
Morning.
Yes, morning.
Morning.
Thank you for joining today's session. Like always, please mute your mics and only unmute yourself if you want to say something or if you have a question. Today we are going to talk about civil unions. So before we start, I just want to ask, just one of you or two of you, what do you understand when we talk about civil unions? You know that in South Africa, we've got 3 types of marriages. We've got civil marriages, we've got customary marriages, and we have civil unions. So can somebody just tell us, when we talk about civil unions, what are civil unions and how are they different from civil marriages? Prudent, unmute yourself.
I have unmuted myself. Can I go ahead? Thank you.
Yes, you can go ahead.
Yes, civil unions are actually more like civil marriages, but now the difference is that civil marriages are for people of the opposite sex, but people of the same sex who go into civil marriage, into civil unions. It's more like, that's why we call it civil unions. That's a short description I can say.
Okay, thank you so much, Prudent. Anybody else? Students? Prudent, you can put your hand down. Thank you. Students, anybody else? What do you understand when you talk about civil unions? Or how are civil unions different from civil marriages? One of the differences is civil marriages can only be entered into by parties of the opposite sex, while civil unions can be entered into by parties of the same sex, but also by parties of the opposite sex. Civil unions, they're more or less their rights or the legal implications, they are the same like civil marriages. Spouses who enter into a civil union have to be 18 years and above. So when I talk about 18 years and above, minor children cannot enter into a civil union. This is opposite to spouses who enter into a civil marriage, because if you want to enter into a civil marriage, minor children are allowed to enter into a civil marriage, but they must get the consent either from their guardian, from their parents, and also from the relevant authorities. So my question to you is, what is your view on this, that minor children of the opposite sex with the consent can enter into a marriage, a civil marriage, but minor children of the same sex cannot enter into a marriage up until they reach the age of 18 years. In your view, just one of you or two of you, what do you think about this? Is it fair? And why do you think minor children of the same sex are not given the same right as minor children of the opposite sex? Madeline?
I don't think it's fair to exclude minors from entering into a civil union. It violates the equality clause of the Constitution, Section 9.
Thank you so much. Anybody else? What's your opinion on this? Students, please don't be shy. Let's just discuss. And yes, thank you, Madeline. Somebody else? Students? Prudent again. Prudent, is your hand up? Prudent?
Unmute now. I've unmuted now.
Yes, you can talk, Prudent.
Yes. Yes, I think because in South Africa, it's just an opinion. I haven't found it from any authority. I think civil unions are quite a new phenomenon. And to go to those civil unions opposite to civil marriages, we still have a long way to go, and we still cannot really, open it up to young children. That's all I can say now.
Yeah. Okay, thank you for your opinion. If you look at this from the constitutional perspective, minor children's rights are being violated because they are not minor children of the same sex rights who want to get married. Their rights are being violated because there is no reason or there is no basis why they cannot enter into a marriage other than the fact that the Civil Union Act does not cater into them. So there is no legislation that at the present moment caters for minor children who want to enter into a same-sex marriage, but there is a legislation that caters for minor children of the opposite sex. In the media, I think you have seen that there has been talks of proposal to introduce the Single Marriage Act, Single Marriage Statute, which is going to regulate all the marriages in South Africa. So one of the proposals in the Single Marriage Statute is that no marriage must be entered into by a minor child. So in other words, all parties who want to get married, they need to be 18 years and above. So this can be a possible solution for correcting the infringement that is actually being encountered by minor children who are in same-sex relationships, because it will mean that even minor children of the opposite sex can't also enter into a can enter into a marriage, or alternatively, the Civil Union Act can be challenged on the basis that minor children's rights are being violated, and there is no constitutional basis why their rights are being violated. So that is just something interesting. But what you must know is the Act does not cater for minor children of the same sex. You must be 18 years and above. Secondly, the civil union, like civil marriages, it must be registered. However, in terms of Section 6 of the Civil Unions Act, it gives the marriage officers, the right to actually refuse to register or to solemnize same-sex unions on the basis of their religious belief. So that is my other question. There is there has been legal development regarding Section 6 of the Civil Union Act. But before we talk about the latest legal development, what is your view that marriage officers, and now we are not talking about marriage officers who are pastors, priests, and all that. We are talking about marriage officers who work at the Department of Home Affairs. What is your view on this, that a public servant who is employed by the government and they work for the Department of Home Affairs, they can object to solemnize and register a marriage of two people just because they don't believe in same-sex marriages, and their only reason is it violates their constitutional belief? So in your opinion, do you think this is something that should be allowed, or since you work for the government and you are an employee, your personal religious belief play no role when it comes to your position as an employee and when you are acting in your capacity as a public representative, as a government representative? So what is your view on Section 6, which gives public officials the right to refuse to solemnize marriages of same-sex parties? Anybody? Students? Okay, I can see a hand, but I'm not seeing your name. Oh, Jabulani. Jabulani, you can unmute yourself. Okay.
Good morning, ma'am. I think those ones shouldn't get a choice. They should just solemnize marriages. That's their job.
Okay, thank you for your opinion, Jabulani. Somebody else? Is there somebody who believes that, or who is of the view that everybody has a right to have their beliefs respected, and even if I am employed, my employers have the right to respect my religious beliefs, and if I don't believe in same-sex marriages, I should not be allowed to solemnize and to register those marriages? Do we have anybody who holds that view? Mashele Hulani, unmute yourself, Mashele.
Okay, thank you, ma'am. I also believe in the Constitution we have the freedom of religion and the freedom of belief. You see. So I think if my religion doesn't allow me to do so, even if I'm employed, but I still have the right of religion and belief. Yeah. So
Okay.
I'm not supposed to be obliged to do that, to solemnize them.
Okay, thank you for that, Rulani. So the issue of Section 6 is something that has been debated for a long time, because there are those who argue that, like Rulani is saying, although I'm an employee, I have my constitutional right, and you as an employer, you need to respect that. And there are those who are of the view, that if just hold on, I just want to mute everybody. There are those who are of the view that if you are employed and you are acting in your capacity as a public representative, your personal views and your personal morals play no role when it comes to conducting or acting in your capacity as a public representative. So, okay, before I continue talking about the latest legal development on this Section 6, let's just hear what Daniel van Wyk has to say. Daniel, please unmute yourself. Rulani, please remove your hand. Rulani, please remove your hand. Daniel. Daniel.
Good morning, ma'am. Good morning, students. My view is, if it's your job, if it's in your official capacity to do something, although you have the constitutional rights as your person, I think you have to divide those two. If I can mean, like, when they have prejudice against a judicial officer, they're not having prejudice against the judicial officer in his private capacity. It's in his official capacity. So in your official capacity as that person that's solemnizing the civil union, I think you have to make that divide, and you have to be professional. Although you have your constitutional rights of freedom of religion and freedom of speech, etc., 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 those other people have that as well. That's trying to get married. So I think we must make that divide there. But on my stronger point is on minors getting married. That is something I think our law is not prepared for, and I don't think children should get married anyway.
Okay, let me Let me ask you something, Daniel. When you talk about minors, so are you referring to minors of the same sex or even minors of the opposite sex? So in other words, as long as you are a minor.
Both of them. Children,
Okay.
both of them. They are minor, they are children, yeah, it's for something reserved for adults. That's my belief. Thank you very much.
Okay, thank you. Thabo?
Okay, good morning to you all, my learned colleagues, your fellow students. I just want to mention one and two, three things. Here, I was saying, if you refuse about maybe solemnizing the marriage of same sex due to your religion belief, that it won't working as a discrimination to as per the Constitution to Section 9. And what about the Constitution when it says all that is performed unlawfully is invalid as per the Constitution is supreme law?
Okay, thank you for your question, Thabo. Yes, you can argue that it is violating the Constitution, but the Civil Union Act gives the marriage officers the right to refuse to solemnize or to register marriages if that is something that you don't believe in. The Section 6 of the Civil Union Act is what empowers the marriage officers to actually refuse to solemnize these marriages. However, there has been latest developments whereby we have the Civil Union Bill, which has recently been made into law. I'm not sure when it's going to be applicable, whereby Section 6 has been amended and marriage officers who are employed by the government, marriage officers in their capacity as public representative, they may not refuse to register such marriages, but this does not, I think it's only going to be applicable after 12 months, or 24 months from the date that it has been signed by the president. So at the present moment, they still have the right to refuse up until that section becomes law and they are going to they now will no longer have the right to reject or to oppose solemnization or registering of these marriages, same-sex marriages, based on their personal beliefs. So that is a change that is gonna be coming in the near future, but at the present moment, unfortunately, they still have the right to do that. But when we talk of marriage officers from the religious section or from the religious sector, they still, even with the amendment of the Act, they still have a right to reject because there will be marriage officers, but acting from the religious sector and not necessarily acting as members or in their capacity as public representative from the government.
Understood.
Okay. Thank you. Somebody had raised his hands, but I'm no longer seeing. So we are going to continue. With civil union, it is a monogamous marriage, so it can only be entered into by two people of the same sex or two people of the opposite sex. By saying two people of the opposite sex, basically it means opposite sex parties have the option of entering into a marriage either through the Marriage Act or the Civil Unions Act, while same-sex parties can only enter into a marriage using the Civil Union Act. So this, again, it can be seen as infringing the rights of parties of the same sex relationship, because why must parties or lovers of the opposite sex be given the right to enter into not enter into two separate legislation, but they are given the choice to decide whether they want to get married in terms of the Civil Union Act or get married in terms of the Marriage Act. But same-sex lovers are only restricted to enter into a marriage using one legislation. But as I said, that there are talks of introducing single marriage statute for all marriages. So if this single marriage statute passes, it can actually deal and sort out this discrimination of same-sex spouses who are only limited to one legislation versus those of the opposite sex. In order to enter into a civil, a legally recognized civil union marriage, the parties must have capacity to act. Capacity, they must be 18. None of them must be in a civil, none of them must be in a civil marriage with anybody else. None of them must be in a customary marriage. They must both be single. If one was married in a civil marriage or maybe in a customary marriage, before they can enter into a civil union, they must have legally terminated their marriage. That also includes a spouse who was in an unregistered customary marriage. They cannot enter into a civil union before terminating their unregistered customary marriage. Secondly, the parties must voluntarily agree that they are going to enter into a marriage in terms of the requirements of the Civil Union Act. Nobody must be forced to enter into such a marriage. And thirdly, the marriage must be lawful. The formalities, if we have spoken about the marriage officers, just like in civil marriages, a civil union which has been solemnized by a marriage officer who is not recognized or who does not have the powers to solemnize marriages will lead to the civil union to be rendered null and void. So parties who enter into a civil union marriage, they need to ensure that the marriage officer is legally allowed and has the legal powers to solemnize marriages. They need to follow the formalities. The formalities are almost the same as the ones that parties who enter into a civil marriage that they enter into. And for a detailed information on the formalities, please go to your textbook, because some of the questions will be in your multiple choice questions during your exams. So please just know the formalities of entering into a civil union. When it comes to registration, just like with civil marriages, civil unions must be registered and the parties must sign the marriage register upon the marriages being solemnized. Next week, we are going to talk about customary marriages and the difference between customary marriages, civil marriages, and civil unions is that customary marriages, upon the parties entering into the marriage, they don't have immediately have to sign the marriage certificate. But with civil marriages and civil unions, the parties must enter into the marriage certificate, and they have to ensure that the marriage is registered. The marriage is registered. If the marriage is not registered, they can bring a court application and have the marriage registered, as long as they can prove that they entered into a legally recognized civil union. Now, consequences of a civil union. The consequences are the same as those of parties who entered into a civil marriage. They have invariable consequences that are the consequences that the parties cannot contract out of them. For example, civil parties who are married in terms of the Civil Union Act, they are still subjected to spousal maintenance. If one spouse is in need of financial assistance, they can sue for spousal maintenance. They have a right to stay in each other's house, irrespective of who is the owner. So all the invariable consequences that you find or that are applicable to spouses who are in a civil marriage are also applicable to spouses who entered into a marriage in terms of the Civil Union Act. And the variable consequences, spouses in a civil union also have a choice to decide if they want to enter into an in-community of property marriage or to enter into an out-of-community of property into a marriage. They have to sign an antenuptial contract. They have to make sure that their antenuptial contract is valid, is not against public policy. So the same consequences that you find in the civil marriages, they apply as well to spouses who are in a civil union marriage. Now, dissolution of the civil union. Civil unions can only be dissolved by a court of law. The consequences are the same as those that apply when civil marriages are terminating, with one exception: redistribution of assets. With redistribution of assets, remember, spouses who are in a civil marriage and were married before 1 November 1984, and I am talking about non-Black spouses, because the redistribution of assets now I can say it no longer applies to Black spouses due to the recent Constitutional Court judgment. We spoke about this, I think, 2 weeks ago. Non-white spouses who got married from 1 November 1984 and going backwards, and whose marriages are automatically out of community of property, no accrual system. During the process of divorce, they can request the judge to order distribution of assets, whereby, let's say, for example, the wife says, I've been a housewife for all these years and my estate does not have anything. So, judge, can you please order distribution of assets so that so that some of the assets from my husband's estate can be redistributed into my estate, and although I won't have to leave the marriage empty-handed. So that applies to them. But for spouses who are married in a civil union, redistribution of assets does not apply at all. And this is because of the timelines. Civil union only became law, or only became effective from the year 2006. Redistribution of assets for non-white spouses, you have to be married from 1984 going backwards. And for Black spouses, it only applies if you are married in terms of the recognitions of Customary Marriages Act. In other words, if you are in a customary marriage. So these are the only two groups that can still apply for distribution of assets. All the other groups cannot apply. So this remedy does not apply to them. Before I continue, does anybody have any question? Do you understand, especially when I'm talking about redistribution of assets? Because this is another, I can say another aspect where spouses who are in a civil union, one can argue that they are being discriminated against. Nosipiwe, unmute yourself.
Hi, ma'am. Can I just ask you to please repeat that? I just want to make sure that I capture it correctly.
Okay. Firstly, let me start now. I will briefly and quickly explain redistribution of assets. Redistribution of assets means if you are in a complete separation of property, you are married out of community of property without the application, without the accrual system. And let's say you were a housewife, you use a wife, a woman as an example. You were a housewife and you get married for a long period as an example. Let's say after 40 or 30 years, your marriage terminates. You have the right to ask the court to redistribute some of the assets from your husband's estate so that you don't leave the marriage empty-handed. Remember, when you are married out of community of property without the accrual system, you are not entitled to anything from your husband's estate. So by requesting the court to redistribute, in other words, to take assets from your husband's estate and put them into your estate, this assists the wife not to live empty-handed, but to live with something. For example, if the husband, let's say, had 3 houses, the court can order that give your wife 1 house so that when the wife leaves this marriage, at least she lives with 1 house and you'll be left with 2 houses. So that is the concept of redistribution of assets. Now, when does it apply? For non-white spouses, it applies to marriages which were entered into before 1 November 1984. Meaning, if you got married, let's say December 1984 or January 1985, and your marriage is out of community of property without the accrual system, you cannot use this remedy. You cannot ask the court to redistribute assets from your husband's estate. So, and this, in a way, one can argue that it is discriminatory because why those who entered into a marriage before 1984 have the right to request or have the right to have the court give them this remedy. But for those who entered into marriage from 1985, they don't have the right. So for non-whites, and non-whites, I'm talking about white people, Asians, Indians, Chinese, as long as you are, no, I meant non-black, as long as you are non-black and you got married from 1 November 1984 and going backwards, you can request the court to order redistribution of assets. Spouses who are in a customary marriage, irrespective of when it was entered into, irrespective of whether it is in community of property or out of community of property, with or without the accrual system, have a right to, the court have the right to order redistribution of assets. And this is because of the Constitutional Court judgment in the Gumeta case. We'll talk about it next week. In the Gumeta case, which says for parties who are in a customary marriage, they can use redistribution of assets as one of the remedies available to them. the Constitutional Court only limited this distribution of assets to spouses who are married in terms of the recognitions of Customary Marriages Act. So now, you are a spouse married out of community of property without the accrual system, and you now want to know, let's say you are in a civil union, you are a housewife, and after 10 years of marriage, you want to know, what am I entitled to? If the parties don't enter into a settlement agreement, you are entitled to nothing. Why? Redistribution of assets is not applicable to spouses who are in a civil union act. The act does not cater for them, because for non-black spouses, you should have been married from 1984 and going backwards. The civil union only came to pass, or only became law from 2006. So that does not apply to them. Civil unions say, at the present moment, it is still not clear if same-sex spouses can enter into a customary marriage. But if you entered into a marriage in terms of the Civil Union Act, you cannot use the remedy of redistribution of assets. So now it's you, Nosipo, and your sister. Your sister, let's assume, I'm just making an example, Nosipo. Your sister is in a customary marriage. She has been a housewife for 10 years, and after 10 years, she has nothing in her estate. She goes to court and argues in court that because I've been a housewife and I'm married out of community of property, I now have nothing from my estate. The court can say, oh, because your husband has 4 houses, we are going to give you one. And we are going to do this by redistribution from your husband's estate and putting the house into your estate. But you, Nosipo, because you are in a same-sex marriage with Ntabiseng, in terms of the Civil Union Act, and I have been a housewife for these 10 years, the court cannot give me a house. If you've got 4 houses, the court cannot give me what they have done to your sister, because that remedy is not available to those who are married in terms of the Civil Union Act. Do you understand?
Yes, thank you so much. I do.
Okay, thank you. Lunga, please unmute yourself. Lunga.
Hello, ma'am.
Yes, Lunga, you can hear you.
Yes, so I would like to ask, for instance, let's take maybe now I'm dating my boyfriend. So I'm the one who is working and doing everything. Maybe I buy a house, I buy a car, and he's not working at this moment. Then he gets a job. So when he gets a job, we decide now that we want to be married in the customary marriage. But I don't want whatever that I've worked before we were married to be included. So I would like to ask, which one is that?
You enter into an antenuptial contract. Then in the antenuptial contract, you can decide if you want your whatever you're going to accumulate while being married to be shared equally, and what you accumulated before you got married to not form part of your marriage. So the marriage contract systems, they are the same, irrespective of whether you enter into a civil marriage, a civil union, and a customary marriage. So it is up to the spouses or the parties to decide. All these marriages, the default marriage system in South Africa is in community of property. Even for civil unions, is in community of property. So civil union parties who do not want to enter into an in-community of property marriage, they must enter into an antenuptial contract, and in the antenuptial contract, they will decide how they want their estate. Do they want complete separation, or do they want to enter with the accrual system, but state the terms, what is it that they want to form part of the marriage, and what is it that they don't want to form part of the marriage? Okay, do you understand?
Okay.
Okay, thank you so much. Piwe, your hand is still up. Please, if you don't have a question, please remove it. Thank you. Alfred? Alfred, please unmute yourself. Yes, Alfred?
Yes, ma'am. Yes, are you saying on the same sex in a civil union, according to this redistribution, the court can't redistribute because they are on the same sex and they are married in civil union.
Okay.
Am I right? Okay. Clarity is there?
Okay. The court cannot redistribute because the Civil Union Act does not have a provision for redistribution of assets if you are married in terms of the Civil Union Act. So I don't want us to put it in a way that it seems like same-sex spouses are being discriminated because they are in a same-sex relationship. The reason why they cannot use this remedy is because the act that regulates same-sex marriages did not make a provision for redistribution of assets. The same like what is it? The Constitutional Court now has now protected spouses who are in a civil marriage, but the marriages were entered into from 1 November 1988 and going backwards. They ruled that this is a recent judgment, Sithole versus Sithole. They ruled that their marriages are now automatically in common of property. Because of that, Black spouses who are in a civil marriage now can no longer use redistribution of assets. And this is because when the Constitutional Court was busy correcting this discrimination on this redistribution of assets, it only protected those spouses or Black spouses who are married in terms of civil marriage. Only those who are married from 1988 and going backwards. So the problem now is I'm assuming that we all know, or let me make you aware that customary marriages at the present moment, in terms of the act, can only be entered into by Black South Africans. So Black South Africans who enter into a customary marriage can use distribution of assets as a remedy during a divorce, but Black South Africans who enter into a civil marriage cannot use distribution of assets. This is because of the Constitutional Court judgment in the Sithole versus Sithole. So now, spouses who are in a civil union and Black spouses and white spouses who entered into a marriage, let's say from 1984 going backwards, they cannot use redistribution of assets because there is currently no legislation accommodating them, or no case judgment, no Constitutional Court judgment which says this group can also use this remedy during the divorce. Even though for customary marriages, we have made allowance for them. So you understand, it's just that there is no provision. Let's say the reason why spouses in a civil marriage, civil union, they cannot use distribution is because there is no legislation that empowers the court to redistribute assets in their marriages.
Yeah, no, I think we need to learn more on this one, study more on this one, because I find it a little bit confusing somehow.
Yeah, it is because you need to understand a brief history of the distribution. The days are very important, and the recent court judgment, because the court judgment that I'm talking about, it was only made this year. So it is still a fairly new thing. Understand? But for the purpose of today's session, just know that for civil union, spouses who enter into a civil union, let me just move there, just hold on. Okay, I'm sorry about that. Spouses who enter into a civil union marriage, they cannot request the court to redistribute assets because the court does not have the powers to do that. Okay, thank you. Let's hear what David Letsualo. David Letsualo, please unmute yourself.
Morning, ma'am. How are you?
I'm okay, and you?
And all the students. Ma'am, you just said customary marriage can be entered only by blacks only.
In terms of the act, yes.
Yes. Now of late you can intermarry. So if I got married to a white woman and we decide to go into this customary marriage, will that also hold water if, let's say, in the next 5 years we decide we're going up our way? Can we go through the course to annul this customer, or what do we call that type of?
Okay, customary marriages can only be terminated by a court of law, and you must be in a valid customary marriage. So if your spouse is a non-black, then you can't have your marriage registered in terms of the Customary Marriages Act. Remember, we'll talk about it next week when we talk about customary marriages, but your marriage must be entered into in terms of culture, and both parties in terms of the act must be black South Africans.
Okay, that I understand. I'm just, throwing a spanner in the works, because I see now there's a lot of, white marrying black people marrying white people, and they will also want to go through the customary marriage, in a way. So, so whatever they're doing, it's sort of null and void in terms of the courts.
Okay, it's not null and void, because remember there's a difference between celebration and going to home affairs and solemnizing and signing the marriage register. So in most cases, they will have their ceremonies and everything, but when it comes to the marriage registration, they usually enter into the civil marriage.
Okay.
Yeah, okay. Thank you. Lieutenant Colonel Ntini? Colonel?
Yes, ma'am, thanks.
Yes.
I wanted to check, ma'am, in terms of, you mentioned something that to say out of community of property that has been done before the 1st of November 1984 for non-black. Does that assumes that before 1984, the marriage for blacks was only civil, or it was automatically to be customary?
It was not recognized. Remember, during those periods, black people were not really recognized. So their marriages were not recognized at all. And or they were partially recognized. And in 1984, they introduced the Matrimonial and Property Act. I just need to confirm the name of the act, the Matrimonial and Property Act, which became applicable to black people. That is when they introduced your in community and out of community of property. But for black people, those who were married from 1 November 1988 and going backward, their marriages were automatically in out of community of property. So there was no 50-50, there was no community of property at all. Customary marriages were not recognized at all.
Thanks, ma'am.
Okay, thank you. Patience, Riranzu? Patience?
Morning, ma'am, and fellow students. Yes. I just want to ask, in terms of the redistribution of assets, when the wife approaches the court, or the person whom it's not working or does not have assets goes to the court, is there a limit to what the other spouse can claim or receive from the marriage as granted by the court, or is there specific assets which are allowed to be redistributed?
No, the discussion is of the court. So redistribution of assets is the court's discretion. So the court is the one which decides and on the limit on, so they can redistribute complete 50-50 so that the parties end up getting 50% of each asset. They can distribute 20%, they can distribute an asset. So the final decision rests with the court.
Okay, thank you very much.
Okay. Nosipiwe, is your hand up? Nosipiwe?
Yes, it is. I just have a question regarding the lawfulness, right? In terms of where it says, for example, that adoptive parents cannot marry their children or their adopted kids. But I just needed to find out, can the adopted kids then marry, like siblings, can they marry one another? Because it's just specifically speak to the parents, not really the kids.
No, if the children were legally adopted, no, siblings cannot marry each other.
Okay.
Yeah.
Thank you.
Okay. Thank you. Any more questions? Lieutenant Tini, is your hand up or you forgot to remove it?
Forgot to remove it, sorry.
Okay. Thank you for that. So yes, that is regarding civil unions. You must know that when it comes to divorce, they have the same consequences as parties from the civil marriage, though distribution of assets does not apply to spouses under the Civil Union Act. And when it comes to the constitutionality in terms of the Civil Union Act, let me just ask this, in your view, from what we have discussed today and from what you have observed, maybe from your friends or in the public or in the media, would you say spouses who are in a same-sex relationships and more specifically in same-sex marriages, would you say there is still a lot that needs to be done to accommodate them? Or because they are now allowed to get married, that's it. Basically what I'm asking is, do you think their constitutional rights are still being infringed upon, or their rights are still being infringed upon, or at least they've been allowed to get married, they must just move on with life? What is your view now with regard to same-sex spouses? If you are in a same-sex relationship or you've got friends, are you happy with how currently the law is actually the law when it comes to marriages, family law related aspects? Would you say you are satisfied with how they are being treated, considering that they have been discriminated for a long time? Colonel Ntini? Colonel? Colonel?
I think, can you hear me, ma'am?
Yes, I can hear you,
Hello?
Colonel. Yes, you can talk, Colonel.
I think in terms of the Bill of Rights, that says we are all equal and then we should be treated equally. A lot needs still to be done in terms of recognizing more of their rights so that they can fit in all the categories of marriage presented that everyone is able to access.
Okay,
Thank
you.
Thanks, ma'am.
Okay, thank you. Lastly, what I want to say about the civil union, as are aware, we have what we call, okay, before I talk, Benjamin, did you want to say something? Benjamin Ndleleni? Benjamin?
Yes, ma'am, I can hear you. It is my opinion that as far as their constitutional rights are concerned, I am of the opinion that the government or the law itself has done a lot to try to meet them halfway. So I think whatever has been accorded to them up to now, as far as I'm concerned, indeed it's enough. That's just my personal view. The reason is I've tried to look I've tried to inquire into a Christianity point of view. I've also tried to look at the Islamic point of view, Hinduism, etc. Whatever we have done today, I think it is enough now. However, I just have a question, ma'am, now that I've realized that maybe there are no more information that you want to tell us more. I just have a query regarding this redistribution of assets. Is it only limited to the females? Because many a time when you are speaking, you are saying if you were a housewife. What about if I was a male and I was married prior to 1988 and I realized that I don't have anything and my wife is the one who has more assets? Can I also approach the court to look for this remedy?
Yes, you can. I use females as an example because in most marriages, females are usually the ones who are, housewives. But the same rights that are given to females are also given to males. So there is nothing stopping a male from requesting redistribution of assets. There is nothing stopping a male from requesting spousal maintenance. There is nothing stopping a male from fighting for the rights that women also have them. So in our sessions, when I keep on saying females, I'm just using them as an example, but just know that whatever applies to the female also applies to the male. Okay, thank you. Emma, please unmute yourself. Emma,
Hello?
please unmute yourself. Yes, you can talk.
No, it's with regards to civil union. I just wanted to say, first of all, this civil union thing is new to us, if I may say. So I really think that the Constitution has really tried to accommodate them. The only problem now is the societies or the communities that we're living amongst. It's not that easy for them to accommodate the civil union. So as far as the Constitution is concerned, I think so far it has done its
Okay, thank you for your comment, Emma. Mpo, please unmute yourself.
Yeah, I'm sorry. With the regards of the civil union, and the government, I don't believe they have reached to a point where it's enough yet. I don't like. I'm not personally satisfied with the progress. I feel like they'll still have a long way to go, because I believe it's not equal. It's unconstitutional for homosexuals to not be accommodated in other acts, like such as being able to marry in a civil marriage, and customary marriage. They are only allowed to get married in civil union, which is not fair. What if they are other homosexual relations that want to embark on customary marriage? That's not possible for them. I feel like even with the government in our country, the equality is not yet there. And then with the thing of saying they've met us halfway, I feel like it does not apply, because with heterosexuals, they have tried so hard, and then I can say, met them at least full way, even though they're not there yet, but then they have done so much. So I feel like they can do the same with the homosexuals. This thing of saying they've met homosexuals or us halfway, it does not really apply. A lot still has to be done.
Okay, thank you for your comment, Mpo. Ramowe.
Good morning, everyone.
Morning, Ramowe.
Yes, in my perspective, in my own personal view, I think that act should, be applicable to all marriages. I think one of the reasons why we have a high rate of divorce in South Africa, I think, is because many people enter into marriages with the hope of, enriching themselves, in the short term. So I think, anti-nuptial contracts should be mandatory, compulsory. That's my own point of view. That's what I think. That's what I believe.
Wait, Rabuka. When you say anti-nuptial contract should be made mandatory, compulsory, basically you are saying the default system, matrimonial system, should change from in community to out of community of property. Remember the default system? Okay. Thank you for that. Interesting. Daniel?
Daniel? I'm hearing you. I just want to know one thing. Okay, first of all, there's obviously much more that can be done for when it comes to in the civil union when it comes to same-sex partners. Because the law is a living entity, it's always changing. So there's obviously more that they can do. But my question is, where do they draw the line? Where do they say, okay, we can go to here and that's enough?
Okay, that's a very interesting question, and a bit gonna be complicated because, as you're saying, where do they draw the line? Because if they draw it here, somebody's going to say, but what about 1, 2, 3 steps? Exactly. So as now there's this proposed single marriage statute. If you get a chance, please Google it, just go through it, because it also has its own challenges. Some of what they are proposing, you can just see that this one practically, they will just not work. Unfortunately, you cannot please everybody, starting with the civil marriage, starting with customary marriage, starting with civil unions. But a balance needs to be created so that everybody is equal. I agree, I forgot with the student's name, whereby you cannot say opposite sex lovers can enter into a marriage in terms of the Marriage Act and in terms of the Civil Unions Act, and with the Black people, they can also, if they want, they can start with the Customary Marriages Act and then convert. But with parties of the same sex, you only restrict them to one act, then it becomes unfair, because there is no constitutional reason why at least you can't say they should also be married in terms of the Marriage Act. Again, with the minor children, I know you don't believe that minor children should get married, and luckily with the proposed single statute, marital statute, they are also proposing that minor children should not get married. At the present moment, there is no reason why, if there's Thabo and Thabang, because Thabo is same sex and is 17 years, he cannot get married, but Thabang, because he wants to get married to a female, he's allowed to get married. You understand? So that again is an unfair discrimination based on the sex of the parties. You understand? So yeah.
So basically, there is not going to be a cutoff point where they say
there is not.
This is enough now. So
yes, yeah. So we'll just see if the single marriage statute will pass. But as I said, just think about this. We've got Black people who enter into a marriage, customary marriage. We've got religious people who enter into religious marriages. We've got same-sex parties who enter into same-sex marriages. We've got heterosexuals. We've got, so if you take all of this group and say, here is one act, this act will regulate all your marriages, how are you going to create balance? Because a civil marriage and a religious marriage, they are different. A customary marriage and this one, they are different. So there will always be, but what about this? But what about this? But what about this? So not everybody is going to be happy with the final outcome. But what is important is people should be allowed to enter into marriages, and their marriages should be legally recognized. That is the most important part. Personally, I believe that the single marriage statute is not going to work. You can have a single marriage statute, but in the statute itself have different categories. If you are going to enter into a customary marriages, these are the requirements. Legal, religious, these are the requirements, and all others, so and so. That is the only way, but you cannot group everybody the same. There will just be chaos. Okay, thank you. We'll take the last one, which is going to be Mishoti, Jabulani, and Bongi. Let's start with Bongi. Bongi? Bongi, please unmute yourself.
Oh, hello, ma'am. I just wanted to know, what is the disadvantage of the civil marriage?
There is no disadvantage of civil marriage. Okay, let me put it like this. Remember, we've got you enter into a marriage. There are the requirements to enter into a marriage, and what is it? You enter into there's the marriage property system, whereby is your income into your out of community of property. So all these marriages, they have the marriage regimes which are the same, the implications are the same. And then when it comes to entering into a marriage, it's like civil marriage, you're just required to go to Home Affairs or have a marriage officer. Civil union is almost the same like civil marriages. Customary marriages have to be entered into in terms of customary processes, and then religious marriages, though religious marriages are currently not legally recognized. For the purpose of this discussion, let's assume they were legally recognized. So they have to be entered into in terms of their religious rights. So that is just entering. But when it comes to the marriage consequences of your income out of community, is the same. It's the same. It just depends. If you chose in community of property, it has its advantages, its disadvantages. If you get married out of community of property with the equality, it has its advantages, its disadvantages. If you enter out of community of property without the equality, it has its advantages, and its disadvantages. What you need to understand here is when you get married, just understand how the whole systems work, even for your clients. When clients come to you and say, we want to enter into a marriage, this is what I usually advise people, that before you can even go and sign, go and speak to somebody so that you understand the legal consequences of getting married. You explain everything, including what happens during the divorce, the consequences of divorce, the consequences of death, so that your clients can, after that, go and make an informed decision, so that when they enter into a marriage, they must know that, you know what, nothing is 100% guaranteed. I was also warned of the different consequences of them. And the other thing is, when you enter into a marriage, civil union, and customary marriage, these marriage certificates are the same. The only difference is at the bottom part, where the civil marriage is written civil, where the customary is written customer. Civil union is civil union. That's the only difference. But in the end, they are the same thing. It's just the same thing. Adults getting married. Understand?
Oh, thank you so much, ma'am. Yes,
Okay,
thank you so much.
Jabulani?
Yes, thanks once again, ma'am. I think that this discussion evokes so much emotions sometimes. But, ma'am, I think the very important thing that is in my mind, I just wanted to say my little bit on it. I think the most important thing is that the people who go into marriages should agree first, and that they should love each other. If they so do, if they find that they love each other, then they can get into marriages. It shouldn't be a government issue, man. These discriminatory laws have no place in our society at all. They should be repealed. They should be, if we have a similar set of marriage regime, that should work. That should work. If it works, if it doesn't work, it will take us a long time to get there. I think the law is still very much unfair to same-sex parties or partners. It should change. A lot still needs to be done to get it correct. I fully agree with Paul. We should not be regulated by the government. People should not have their lives or their bedroom issues regulated by a government somewhere. You know, that's just my view, ma'am. I think it should change at some stage, and yeah, that's where I stand.
Yeah. Okay. Thank you for your opinion, Mihloti.
Good afternoon, ma'am.
Morning,
Unfortunately, I joined the meeting very late, but I just have two issues. One of them is prompted by the message that I see here, which has to do with polyandry. I think the comment is saying there's a proposal for polyandry, which I have not heard of, but I'm just thinking, I just wanted to check, because as far as I know, in South Africa, there isn't any customary law system that is following this kind of marriage. I think maybe it was followed somewhere in West Africa.
Yeah, yeah.
So I'm just wondering, let's say, okay, I don't know about the proposal, but where is the proposal coming from? Because I'm thinking that in terms of customary law, there will have to be an interest from those groups themselves to have this kind of marriage legalized. The second part of the question had to do with customary, not heterosexual, same-sex marriages. Even the same will have to be proposed by the groups themselves. I don't think the government can just decide and say, we want same-sex marriages to conclude their marriage in terms of customary law. Because remember, it is the groups themselves who have to make sure that the law, customary law, develops. So I just want your opinion in terms of that, if say we want this kind of marriages to be recognized, who should initiate this? Thank you.
Okay. As you are saying, it's supposed to be the group themselves. For polyandry, not apparently, unfortunately, at the present moment, there is no group of people who actually follow this system, but how it came into about for it to be a discussion is because of these talks of the single marriage statute. So as they were discussing, and then because men are allowed to enter into, African men or black men are allowed to enter into polygamous marriages, in terms of the proposed marriage statute, they are now extending this to those who are in a cohabitation relationship, because this single statute is not only going to give rights to married spouses, is also going to accommodate those who are in cohabitation relationships. So if unmarried men who are in cohabitation relationships are going to be allowed to also have 2 or 3 girlfriends. Now, why can't we also just allow women to also do that? Because constitutionally, if adults decide to enter into a relationship, nobody was forced, why should they be restricted? If there's too many who do not have a problem to marry one woman, why should that be restricted? Understand? So, but if there is a woman who can go and challenge the non-legal recognition of polyandry at the Constitutional Court, they will have a successful application, because there is no reason other than the fact that it is a woman who wants to marry 2 men. There is no constitutional reason why women should not be allowed to marry more than 1 man. And then with regard to civil union entering into a customary marriage, customary marriages which are entered into in terms of the recognitions of Customary Marriages Act, it states the act, the marriage must be entered into in terms of culture. So the question now is there a cultural group, a cultural tribe which recognizes parties who are in a same-sex relationship. If there is one, then they can enter into a customary marriage and they can say because of a Bashobic tribe or whatever. So what is making difficult to recognize same-sex parties is because the marriage must be entered into in terms of customary practices. So which is that customary practice? If you go to court and there's a dispute, you have to say, but the Bapedi of this tribe, they are in terms of their tribes and belief, they enter into same-sex marriages. So that is the only way they will be protected. To understand.
Yes, thank you very much, ma'am.
Thank you. Lunga.
Hi, ma'am.
Hello, Lunga.
So I need to ask a question. So for instance, let's take maybe two people are getting married. So the husband is going to pay lobola, but they only pay half, and there's no celebration after that. They only pay lobola in half. So is it recognized as in community of property? Because in many instances, maybe if the husband dies and they only paid half, sometimes they give problem because the family of the husband, maybe sometimes they chase their wife out of the house and taking the property of the husband and say that they did not marry.
Okay, please pause that question. We're going to talk about it next week because next week we're talking about customary marriages. So we are also going to talk about the challenge of what you are talking about, especially since there is now a conflicting judgment from our courts. Okay, thank you. Please join next week. The last one, we're going to have Mpo as the last one. Mpo? 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 Mpo, please unmute yourself.
Hello again. I had a lady before. I don't know, like maybe two people prior to you. Talking about the government can't all of a sudden just catering allow or allow like for example gay people just randomly give them a certain act and then it's our responsibility to initiate that. And I believe personally that equality is compulsory. It shouldn't be our thing or our job to initiate and it's a particular act so that it can be applied to us. I believe if there's any act that exists, it should apply to everyone. It shouldn't be fight or protect so that we can be recognized or we should initiate any act. If there's an act that applies to heterosexual people, same applies to the homosexual people. It's not our responsibility as homosexuals to initiate or to pursue the government to give us a certain act or like that. Like equality is just compulsory. Whatever applies to homosexuals, it should apply to heterosexuals and vice versa.
Yeah. Okay.
Ma'am, can I clarify before you come in, because it was me who said that. Yeah,
Okay.
I think what I was saying, I was talking about this in terms of customary marriage to say, in terms of culture at the moment, I don't know any culture, whether the Tsonga, the Venda, the Zulu, who actually recognizes same-sex marriages. So what I was saying or asking was that, isn't it the responsibility first of that cultural group to say, okay, from today we want to amend our customary law and we now want to extend the definition of marriage to also cover same-sex marriages? And then they make such a proposal to the government, because I think it will be very difficult for the government to just up and decide that, okay, we now want to extend in terms of Customary Law Marriages Act to this kind of marriage to apply to same-sex marriages, because they will hit a wall. I mean, all the cultures are going to say, but in terms of our system, we don't have that. Yeah. So I think it's not something that is just going to be easy to initiate, but if the cultures themselves were to stand up and say, we think there is a need here, as he said, it's everybody's right to be able to get married when they are in love and want to get married, regardless of the sex. So I think that's what I was coming from with my comment. Thank you.
Okay, thank you, students. Let's just hope, even though I'm not that hopeful, that the Single Marriage Act, the proposed Single Marriage Act, will accommodate everybody. That is, if some of the proposed proposed clauses now, some of the controversial proposed clauses, they actually gets changed so that everybody gets to be accommodated. Next week, we're going to talk about customary marriages. So please read on it, and also just be mindful of the recent case development, especially from the Constitutional Court and the Supreme Court of Appeal. I think last year there were two major landmark judgments which actually brought about some changes to spouses who are in customary marriages. We will talk about it next week. For today, that's the end of our session. Please have a lovely day.
Before you leave.
Okay, please, yeah, I'll come back. I'll come to you now. Please have a lovely day and good luck with your exams on other modules and as we are preparing for the family law module. Okay, who's speaking? Who said before?
This is Tabota speaking.
Okay.
Yeah, it's just a partly question that related to this, what we're doing. I was just asking, don't you think that is time for Parliament to introduce this the expiring date for marriage certificate? Because now if you are introducing this single marriage statutes, then there's a lot of things that need to be done.
Okay, no. There can be an expiry date. Remember, if you no longer want to get married, you are free to file for a divorce. Divorce is no longer like before, where it used to be a complicated system or a procedure. You enter into a marriage. When you enter into a marriage, you are saying until death do us part. But if you can see that you cannot wait for death to occur, you can just go to the regional court and just file for divorce. You don't even necessarily have to go to the High Court. Okay, thank you, students. We shall see each other next week. Have a good day ahead. Goodbye.
Thank you. Bye.
Thank you, ma'am. Bye.
Thank you, ma'am. Goodbye.
Bye.
Goodbye.